Hi, welcome to Authentic Ingenuity Entrepreneur. This video clip will be focusing on the fourth court hearing of this same court case, following from my last video clip. So at the moment, the hearing is still currently in the judicial review process. So I'll be walking you through what happened in the fourth hearing of this case. The judge is still the same. Excuse me if I keep looking down because I've got my notes here so I can make sure that my information is accurate. At this stage of the hearing, the case is still before the same judge, which is Judge J. Goss. The parties of this hearing was myself, the applicant, and then it was for the appearance for the Crown was Suzanne Shaw, and she appeared by VMR. So the hearing wasn't a very long hearing, it was quite short. The counsel appeared by VMR, so it was completely a different format that I'm not used to. But now at this process of the case, counsel appeared by VMR recording for a judicial review list hearing. What actually happened at this hearing? And it is before Judge J. Goss. At this hearing, all the parties were there, and Judge opened court, and Judge said that he was going to deal with counsel's application first because the counsel's application was formal and mine was informal. And with that, I was, a little bit kind of confused because this is a new system. Anyway, I addressed the court. Judge didn't want to get into a big conversation about it. He was going to adjourn it to another hearing. And then I asked the judge if he could verify what did he mean by my application was informal and counsel's application was formal. So I was a little bit, I wasn't going to just not say something about it because, I'm going by what I'm used to and what I believe our laws are still the same. Anyway, I did approach the court, and as far as I was concerned, and from other people that I have already spoken to, it hasn't changed. So I wasn't happy that counsel's application was going to be first, obviously, because it was my case. And so judge had approached the court at this hearing and dealt it as the counsel's or the Crown or the defendant's case over my case. So when judge made that decision in the hearing, I approached the court and I asked him if he could verify what he meant by my case. My documents were informal and counsel's documents were formal. Obviously I knew, they had put in an interlocutory application. That's what's happened, and so at the moment we're still dealing with my application. And so what had happened was counsel had put in an interlocutory application. I wanted to hear from the court what he meant by my case, that my forms were informal, because they weren't informal according to what I had submitted. So that is what judge said. He said that the counsel's application was formal and my application was informal. That's what was said in the court. Judge wouldn't elaborate or talk about it anymore. that's what it is. That's what he said, and that was the end of that, which was fine. If you've ever been in the courtroom, that's how court is. Whatever the judge says, that's what happens. And I knew it wasn't fair. This is from my point of view, because the hearing before that led up to this case was before another judge. So got to bear in mind, so there's two separate judges already, but the judge that first opened up the judicial review process had given me an instruction that I had to serve the Ministry of Health and City Med, reserve them because the other party had made claims. They addressed the court as if I hadn't done my bit legally, but I knew I had. But anyway, that judge had advised me to reserve the Ministry of Health. So, and with that, I had put together of documents that both City Med and Ministry of Health had been served 4 times in total, and the legal names of the actual party is definitely Ministry of Health and City Med. So that's why I was a little bit confused, because I thought, hang on, I had put in exhibits, because I put them all in an exhibit form, and council at this time had only put in at this actual hearing but we go also bear in mind it's a new council for Ministry of Health, so it's no longer the key chambers, it's the new council for the Ministry of Health is brand new with this case. So they don't know the history of the case, so they're kind of new on board. I did advise the court that both parties for the councils for the Ministry of Health and City Med had not withdrawn legally as from the case, which is the usual normal procedure. So I'm representing myself personally, so anything I do about my court case is not confusing to me because it's mine. So you can see the difference of getting different people in and taking bits and pieces out of somebody's life. What I'm trying to say is that I haven't changed, my story hasn't changed. Everything that I said that I've done, and if it's not there now, if somebody has deleted it, but that's what's been happening. So at this hearing, it was definitely a new council for the Crown, and at this time it was Suzanne Shaw, but I did notify the court on the next hearing, which I will do a separate clip for that one. So at this hearing, Judge Jacobs, he said, well, first of all, the reason why I wanted to address the court and ask the judge and hear where he was coming from. And you know, I was like, hey, that's not fair, because it wasn't fair, because I knew, everybody knew, that my case should be first. Like the applicant always overrides the defendant, doesn't matter who the defendant or the plaintiff is. That this new system clearly, I mean, I didn't know this until I actually went through it myself, and I was like, oh my gosh, this is terrible. But anyway, I just, you know, you don't know these things until you actually experience it personally. The reason why I addressed the court about it is because I wanted them to know that I didn't consent to it. I didn't consent for the Crown or for the defendant's case to go before me. I hadn't consented it, and that's the reason why I asked the judge to verify and confirm what he meant. And then I said to him, but it's my case and the Crown is the defendant. But that was the judge's call at this hearing. So that's what happened. And with that, the judge sent out a minute on the 26th of April, and he set us a schedule. Judge set us a schedule for both of us to follow. What I must mention in the hearing was judge had said to me that I hadn't responded to the Crown's, the Crown had sent out a memo to initiate a schedule. So I was I was a bit like, hang on, because I'm used to the court registrar in the court, you know, who case manages it, who case manages a case. By law, there's a reason why they did this in the old system, is to separate the judiciary and the parties from, you know, so they don't do this prejudice side thing and they know each other. And but in this new age system, I have found that the case officers are not actually case managing our case initially according to the laws. And what I mean by that is that they're not actually taking on full responsible or giving instructions to each party to separate the prejudice or anything like that. So when the councils sent their application to initiate, it's usually the court deputy registrar or the case officer that actually is the one, like the middle person between the judiciary, between the parties, which is the defendant and the plaintiff. But in this case, this new age system, the power of the initiating of what goes on with court, seems that the case officer or the deputy registrar or the registrar is not really case managing, but rather it is the defendant telling the applicant. I know that sounds like, if I explain it that way, you know, it is Crown and it is, I am the applicant, but the fairness of what's going on, it gives the Crown, who is actually the defendant, superior and calling the shots, and like, hang on, they've broken the law, I'm the applicant and the victim, you know, where's my intervention? And then I had found that the case officers, or who is usually responsible to actually case manage the case between the judge and the parties, and that kind of supposed to separate any prejudice, any family thing or friend thing going on. So you can understand, I mean, everybody wants to win their case, but that's not fair. Anyway, that's what happened, and that is what I'm finding out in this process.